This is Colin O'Keefe here for LXBN TV. Last week, the Supreme Court heard oral arguments in a religious discrimination lawsuit against Abercrombie Fitch, in which the court will examine if the company's look policy, which potentially led to one Muslim woman not being hired for wearing a hijab to the interview, constitutes, again, religious discrimination. Joining me to reflect on the oral arguments is an attorney out of Chicago. He's one of the top EEOC lawyers in the country. That is Jerry Maatman with Seyfarth Shaw, an author on the firm's blog, Employment Law Lookout. Jerry, first off, let's just get, what are your initial impressions for how the oral arguments went? Is there anything that stood out to you as far as the justice's line of questioning or anything like that?
Well, Colin, thank you for allowing me to join you today. I think it's hard to draw concrete conclusions from the questioning or the tea leaves from the questioning, but it was pretty clear that everybody's position, both the EEOC and the employer, had rough sledding before the justices in terms of, will this case be a door opener or a courthouse closer in terms of how easy or hard it will be for the EEOC or a private plaintiff in a religious discrimination case to make out a claim for a denial of reasonable accommodation. I think it is pretty clear that the Supreme Court simply didn't accept the Tenth Circuit's decision, a case which had rejected the EEOC's position on whether or not a reasonable accommodation was needed. I don't think the Supreme Court accepted the case simply to affirm it. And the Supreme Court's questions seem to indicate that the rule advanced by the employer in terms of we really don't have to explore the basis for a reasonable accommodation unless the applicant asked for one was an argument that fell on deaf ears. So it seems to me that the takeaway is going to be some sort of rule between the extremes argued by the two sides, and the Supreme Court seemed through its questions to be groping for somewhat of a practical solution to an everyday problem that takes place when applicants are interviewed by companies.
I see, and of course, I've heard a number of times, like with these oral arguments, oftentimes the justices have almost made up their decision before these oral arguments even happen. They'll probe on certain things, but a lot of times, if their decisions aren't made here, they're still made throughout the briefs and that type of thing, more so than the oral arguments. But still, you mentioned, some kind of more practical solution. Do you have any idea for, how the court will rule in this case, the type of practical solution that they're looking for? Where do you, specifically think this is headed?
I think the opinion, when ultimately rendered, will focus on what quantum of information does an employer need to have to trip the obligation to discuss whether or not a reasonable accommodation is needed on religious grounds for the applicant. And so I think it'll be a facts and circumstances test. I don't think it will be a unanimous decision. And I think what it portends for employers is increased training by hiring officers. And for a litigation context, it means probably summary judgment is less likely in these cases because that quantum of evidence or what needs to be done with that information will be a facts and circumstances test that will vary and therefore make summary judgment difficult to obtain. So I think it will be somewhat of a door opener decision, and the courthouse doors will be open to more applicants, more litigants, and more situations.
Absolutely. This is going to be interesting to watch. Sometimes people look at the courts as almost kind of a punitive measure to strike something down or, hit somebody on the head when they do something wrong. But it's interesting here that hopefully they reach some kind of, middle ground going forward where both employers can accommodate accordingly, but do so in a way that works for everyone, it seems.
I would agree, and I think this is a good example of a situation where the ruling will have practical, everyday significance for employers and their hiring officers and for people looking for work.
Absolutely, absolutely, and I look forward to seeing how this all turns out, and of course we'll keep an eye out for your analysis as well. Once again, that was Jerry Maatman of Seyfarth Shaw. For more insight on this case from Jerry and his colleagues, you can find that at laborandemploymentlawcouncil.com. Thank you for joining me today, Jerry.
Thank you.